Thank you for being here today. Welcome to ATOM's webinar on understanding and managing rights under copyright law. We are delighted to welcome our speakers from the United States Copyright Office and the Sandra Day O'Connor School of Law at Arizona State University. Our webinars are designed to provide information and tools that you can use to help you carry out your responsibility on important topics with engaging speakers. I am pleased to introduce Nancy E. Weiss from the Copyright Office, who will frame the program and introduce today's speakers. Nancy previously served as the General Counsel of the Institute of Museum and Library Services, Senior Advisor for IP and Innovation at the White House, and Deputy General Counsel of the National Endowment for the Humanities. Her work over the years has focused on the intersection of law and cultural activity and has informed many different types of support for tribal museum, library, and archival services. Thank you all for being here today.
Thank you, Melissa, and good afternoon, everybody. Thank you for joining this webinar, which I know is going to be a dynamic one. We're joined today by Miriam Lord, who is the Associate Register of Copyrights and Director of Public Information and Education for the United States Copyright Office. She leads a team that provides authoritative information about copyright law to the public, develops education and outreach programs like this webinar, and responds to public inquiries about office policies and practices. And that's just among other things that you'll learn about. She is an expert copyright attorney and one of 4 legal advisors to the Registers of Copyright. Professor Trevor Reed is also speaking today, joining from the Sandra Day O'Connor School of Law, which is part of Arizona State University. Dr. Reed teaches courses in intellectual property and federal Indian law, and his scholarship focuses on the linkages between creative production and Native American sovereignty. So our objective during the next hour is to introduce the Copyright Office, review basic concepts under copyright law, and then work through a few examples to explore how these concepts apply in particular circumstances. We're going to do so with the following format. Associate Register Miriam Lord will discuss the copyright law, including how its provisions identify what is copyrightable, how authorship is determined, and the types of agreements that can exist between or among parties. Then Dr. Reed will apply these copyright concepts to specific scenarios that we think will be of particular importance and relevance to you, and interesting. While the presentation will focus on the U.S. Copyright Act, the areas we will be discussing may also involve compliance with tribal laws and protocols. To make this 1-hour webinar as informative as possible, we've reviewed the questions that you provided in advance and have tried to incorporate them into our presentation. We're going to cover a lot of material, so our ability to respond to additional questions right now may be limited, and we will follow up this presentation with a set of tools and resources for you to use, along with the survey that we would very much appreciate you complete as we develop programs like this with your feedback in mind, and these particular areas that would be of interest. We will also provide a Copyright Public Information Office contact for any questions that aren't answered by today's presentation. Our goal today and always is to provide tools and information to help you make informed decisions when participating in the creation and use of works. So with that, Miriam, let's get started.
Great. Well, thank you so much, Nancy. And I'll just have you go to the next slide. Thanks so much. All right. Well, so good to be with you all today. Thank you so much for having the Copyright Office as a part of this. We're just honored to be included in this discussion because it's an important one. So as background, the U.S. Copyright Office was founded in 1870, and we're a federal government agency that's a part of the Library of Congress in Washington, D.C., so part of the legislative branch of the federal government. So when we talk about the Copyright Office administering the Copyright Act, it's a broad statement and it has a lot of different roles within. So we'll look at the various ways that the Copyright Office carries out its mission. Next, please. So our mission statement at the office is to promote creativity and free expression by administering the nation's copyright laws and by providing impartial expert advice on copyright policy for the benefit of all. So first, we make and maintain records that provide details on copyright ownership, which includes registration as well as recorded documents about transfers of ownership. We also advise Congress on copyright matters, which includes the registrar, who's the head of the agency, testifying upon request and providing ongoing impartial expertise on copyright law and policy. Similarly, we work with other government colleagues to deliver critical policy analyses and advice. Last but not least, we provide authoritative copyright information to the public. That includes by answering questions that come into the office through the Public Information Office and other sources, and developing educational programs like this one. All the great resources we've highlighted and we're going to highlight today, explaining copyright, are developed, maintained, and updated by our staff. So here's a couple of pictures of us at work. Next. Okay, so let's dig into this. What is copyright? So briefly, copyright is an area of law that gives legal protection for various forms of creative expression. And what that means for you is understanding the difference between copyright and other areas of intellectual property, and also understanding the limitations of what copyright provides. So some examples could include films and documentaries, including any incorporated interviews, audio recordings, photos, songs. Within songs, we have sound recordings as well as film performances of music, and then books and stories that have been written down and kept privately or have been published. Copyright law also protects all kinds of other creative works that we may not get into today. Next slide. So what's the source of copyright law? Copyright is a federal law, and it's stated in the US Constitution in terms of its goals in Article 1, Section 8, Clause 8, where Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So this language gives Congress broad authority to advance knowledge and providing authors with certain exclusive rights over their works for limited time. Copyright law is found in Title 17 of the US Code. So that's the statute that governs copyright law coming from the Constitution. This is known as the Copyright Act. Law itself states that copyright protects original works of authorship, which have been fixed in a tangible medium of expression. First, we have to have a work of authorship, and then that work must be fixed and original in order to be protected by copyright. Fixation basically means that the expression has to be written, recorded, or otherwise captured in a copy and must be sufficiently permanent or stable to be perceived or reproduced or communicated for more than just a transitory duration. So the moment a work is fixed is the moment that copyright protection begins. There are a couple other components of what defines copyrighted work. One of them is originality. So originality in copyright has two components. First is independent creation, and the second is sufficient creativity. Independent creation just means that the work has to be independently created by the author. So it's original to the author and it's not copied from another work. In theory, there can be independent creation of the same work. So two works could be the same or similar in each subject to copyright protection, as long as they're by chance and not the result of copying. This is a distinction from other areas of law, like patent law. Sufficient creativity requires the work contains at least a small amount of creative expression. Words, short phrases, familiar symbols and designs, including shapes and typeface or lettering, are usually not protected by copyright. A work of authorship is what we're talking about when we talk about the subject matter protected by copyright. Next slide. What kind of works are we talking about here? So here's some examples when you think about what fits into this framework. Literary works, books, novels, musical works, including any accompanying words, dramatic works, including any accompanying music, pantomimes, choreography, pictorial, graphic, and sculptural works, including fine and graphic art, motion pictures and other audiovisual works, sound recordings, and architectural works. And I'll just make a quick note that in a recorded song, for example, two of these exist, both the musical work, the underlying songwriting, and then also the sound recording itself in that performance. And I'll wrap up here and transition over to Trevor for some applied examples.
Well, wonderful. Thank you, Miriam, Nancy, and Melissa. I'm so honored to join the U.S. Copyright Office and ATOM on this webinar, and I'm streaming to you from here on the lands of the Akimau O'odham people. So let me just take a quick second and review a little bit about what we've learned so far, and also see if we can apply some of this to a fact pattern that might actually be familiar to you. So let's go ahead and see the next slide. So let's suppose a tribal librarian has this great idea for a podcast to help tribal members learn their language. So to get started, she makes a list of some really vivid, evocative words in her native language. Then each week she chooses a word from the list and goes out into the community to record fluent speakers using that word in a sentence off the top of their head. And that ends up producing some actually pretty funny results. Now that she has the recordings, she needs to make this podcast. So after pressing record on her computer, she introduces the word, talks about its meaning, and then she plays some of the examples that she recorded. And then to close out each podcast episode, she makes a mashup of the recordings and sets them to a great beat she downloads from the internet. All right, so let's think through what kinds of copyrightable works she's created in the process of making this podcast. Let's hit the next slide. Well, let's start with what about this idea for a language podcast? Well, unfortunately, no. Ideas, concepts, processes, systems, even facts and histories generally aren't copyrightable. So she can't really copyright the idea for a language podcast. But what about her vivid list of evocative words in her native language? Well, as it turns out, words and short phrases generally aren't copyrightable either. Copyright also doesn't generally cover languages, though some tribal laws might provide that kind of protection. Her selection of vivid, evocative words probably took a good amount of creative thinking, though. So, congratulations, this list actually might be copyrightable as a literary work. Okay, what about the sentences the fluent speakers shared with the librarian? Could those be literary works? First, I want to point out that simply coming up with a sentence doesn't make it a literary work. They have to be recorded or fixed in a tangible medium, like Miriam just said. Since the librarian recorded them, we've got that covered. But since these sentences are probably just short phrases, they probably aren't literary works. Now, if the speaker told an entire story about a word and the librarian recorded it, sure, that might be a literary work. But in this case, just a single sentence probably isn't long enough to qualify. Now, the recording that the librarian makes of the speakers sharing their sentence actually might be copyrightable. Just like a photographer taking a picture of someone, a recording of someone creates oftentimes a copyrightable work, what we call a sound recording copyright. All right, last but not least, we have that mashup, and you've probably guessed that this is a copyrightable work. It's what we call a derivative work, a work created by taking one or more pre-existing works and then recasting them, transforming, or adapting them. Here, the librarian took not only the track from the internet, but also the sound recordings that she made and then pulled them all together. We'll talk a little bit more about derivative works in just a second, but I just want to make you aware using someone else's work illegally to create your own derivative work will actually invalidate your copyright. Last but not least, keep in mind that tribes may have their own protections in this area, so make sure that you check a tribe's own tribal code to make sure that everything is clear on that front. Okay, thanks everybody. Let me pass the baton now back to Miriam.
Thanks, Trevor. So it's good to have a practical application of these, what we call black letter law concepts. Next slide. All right, so say you've created a work. What does it mean to have created that work to be the owner of that work? Well, copyright owners have exclusive rights in their work. So you may have heard these referred to as a bundle of rights. So there's 6 total, including the right to reproduce. That means make copies of the work, to make derivative works, as Trevor was just referring to. That includes adaptations, remixes, translations. The right to distribute copies to the public, transfer of ownership, rental, lease, or lending, and for certain works, the right to publicly perform or display it, depending on its medium. Additionally, the copyright owner of a sound recording has the right to perform the sound recording publicly by means of digital audio transmission. Copyright owners can engage in any one of these rights and can also authorize others to take the action the right provides. Copyright infringement generally happens when any one of these rights is violated. That means when someone isn't authorized to take an action that's listed. So just to do a quick overview of that, there are exclusive rights that inure to a copyright owner as soon as that work is fixed in a tangible medium. We'll get in a little bit later to some formalities that can follow with that. But in general, you have the right, it's fixed, it includes a bundle of rights. This is that bundle of rights. Next slide. So who can own a copyright? The people who write stories, record songs, produce films, own the copyright in that creative output, which we call a work. Creator of a work or the author is the copyright owner. That copyright owner may choose to transfer or license that work, but they start as the owner. Works can be created by one person. They could be created by a group, subject to the terms of the law and the arrangements, like a contract, between the parties involved. I'll talk a little bit more about each of those areas. Next slide. All right, so we're going to get into a concept in the law called work made for hire. In the case of works made for hire, the author is an employer or a commissioning party. This is a category of works within made for hire are those made by an employee as part of their regular duties. There's a couple considerations when determining whether an employer owns the copyright in an employee's work. And this includes where the work was created, whether the space, tools, and materials used were provided by the employer, the level of control the employer had over the work, and other things. Second type of works made for hire are those that were completed as work as a result of an express written agreement between the creator and a party specially commissioning the work. So certain requirements have to be met in order to have a commissioned work made for hire. First, the work has to fall into one of the 9 categories mentioned in the Copyright Act. We're going back to that statutory language here. For example, this includes a contribution to a collective work, for example, part of a motion picture, other audiovisual work, or translation. There has to be a written agreement between the party that ordered the work and the creator. And in the written agreement, the parties have to expressly agree and state that this is a work made for hire. Finally, of course, the agreement has to be signed by all the parties. So if all the requirements are met for one of these types of works made for hire, the employer or the commissioning party is considered the author and therefore the copyright owner. So again, paying someone to create something doesn't necessarily mean that you automatically own the copyright in it. You need to enter into this work made for hire commissioning agreement, or they need to be your employee, and this is within their scope of work. This is a complicated area. So for more information on this concept, we have a lot of accessible plain English types of resources. And this is what we, on the screen here, you'll see one of our circulars here. A circular by the Copyright Office is a piece of educational content that explains things in a way that takes statutory or constitutional language and breaks it down. These circulars have been around a long time. We used to distribute them by mail, but now they all live on our website and have up-to-date information that's authoritative on copyright law, policies, procedures, registration issues. So this is Circular 30 on works made for hire specifically. I would highly suggest you dive into it. We can give you some links and of course, provide that anytime through our public information office. In Circular 30, it's a really helpful questionnaire that can really help you determine whether or not a work is a work made for hire. This is really relevant when you're submitting a registration application to the office, which we'll get into later, because you'll have to answer a question about whether you're trying to register a work made for hire. We can't make the determination as the Copyright Office for you, so it's a good resource to help you in your decision making. I always like to say to people that it's very important to know what you have and to understand your relationship with others when you're thinking about concepts related to copyright. This is one way to help you get there. Next slide. All right, so another way that you could have relationships between people and relationships with a creative work is through joint work concepts. So a joint work is a work prepared by 2 or more individuals, where the intention is that their separate contributions be merged into a single work. Someone who has just contributed ideas without actually documenting those ideas are just generally not considered an author under purposes of US copyright law. Trevor earlier was talking about how ideas alone are not copyrightable. This is part of why. So co-authors own the work's copyright jointly and equally, unless the authors make an agreement otherwise, which of course they're free to do. Each joint author has the right to exercise any or all of the exclusive rights inherent in the joint work, that bundle of rights we talked about earlier. Each author may joint third parties permission to use the work on a non-exclusive basis without the consent of the other joint authors, transfer the entire ownership interest to another person without the other joint author's consent, update the work for their own purpose. And additionally, each joint author has to account to the other joint authors for any profits received from licensing the joint work, like profit accounting. That profit accounting can be altered through an agreement. So basically, in summary, that agreement that you have really governs the relationship that you have when you create a work together. And that's an important thing to work out. And for more on that, over to you, Trevor.
All right, thanks, Miriam. So let me just continue our story about the podcasting librarian, and let me see if we can put a little bit of what Miriam just shared about ownership into context. So let's grab the next slide. So as it turns out, when the tribal librarian recorded each of the speakers, she did so in the library using the library's equipment and made sure the library even paid the speakers for their time. It's very generous. But she didn't require them to sign anything clarifying who the owner of the recordings would be. So we learned from our first review question that the sound recordings may very well be eligible for copyright. But who owns them? The librarian, the community members, both together, or maybe even the library? Well, when you make a sound recording, there are really two contributors involved. The sound engineer who has to control the sound quality and do the editing, and then the speaker who creates the content. At least since 1978, it's been generally accepted that the sound engineer, here the librarian, and the performer, here the fluent speaker, create a joint work when they make a sound recording. They are two or more authors intending that their contributions be merged into inseparable and interdependent parts of this sound recording. But couldn't the library be the owner? After all, the library is paying the librarian salary and paying the fluent speaker. The key question that we asked, just like Miriam said, was this recording created by an employee within their regular duties, or was it specially commissioned through an agreement, making it a work made for hire? If neither of these is the case, it's probably a sole authored or a joint work. For the librarian, the answer is probably yes. It's a work made for hire, assuming she's making the podcast as part of her job. But for the fluent speaker, it's a little harder to say. First, there wasn't an agreement in place. But didn't the library pay them and provide the space and the equipment for the recording? Still, on the other hand, it doesn't seem like a typical employment relationship. The library probably isn't paying benefits or taxes. And this is really only one little tiny assignment, and the library really isn't controlling what the speaker's saying. Fortunately, Circular 30 provides that fantastic questionnaire that Miriam was just talking about that can help guide you through these kinds of tough questions. Based on the questionnaire, I'd probably say the speakers generally aren't employees. So the speakers and the librarian and the library may very well be co-owners of the sound recording copyright. All right, as for the podcast itself, the library is probably the copyright owner. It might be tempting to say that the fluent speakers are joint owners with the library on this as well, but when it comes down to it, it was the library, thanks to the librarian, who was the mastermind of the podcast. While the individual recordings are probably joint works between the library and the speakers, the podcast itself was primarily the product of the librarian's creative work and owned probably just by the library. All right, let's hit the next slide. So what happens when you upload a podcast to a social media platform? What rights are impacted? Well, let's start with letter A here. Is this a reproduction? Actually, yes. Whenever you move a copy of a digital file from one computer to another, that's a reproduction. All right, what about letter B? What about derivative works? Well, yes, here too, but maybe a little indirectly. When you make a creative work available on most social media platforms, you typically also agree, when you sign the terms and conditions, to allow others to use your work to create their own derivative works, maybe reposting it with different content or even mashing it up with theirs. What about public distribution? Yes, this is probably a no-brainer for most of us. Sending files around the public internet is a great example of public distribution. What about public performance, though? Well, this is a little trickier. Anytime you stream a musical work, a literary work, an audiovisual work, you're typically exercising this public performance right. Since the podcast contains a literary work, it will be publicly performed if the podcast gets streamed. You probably aren't exercising any public display rights for this podcast, though you might if the social media platform allows for transcriptions to be displayed. And since the podcast is a sound recording, you're certainly impacting the digital streaming right for the sound recording. All right. Thanks for that. Now let's go back to Miriam for a little more.
Thanks, Trevor. Sounds like a really interesting podcast. So I'm going to get into the concept of licenses briefly. So a license, going back to that concept of having something in writing, is permission for a copyright owner to engage in one or more exclusive right. That bundle of rights we just talked about. It can be limited by time, it could be limited by geography, it could be limited by format or the activity. So when you're thinking about a license or that agreement that you make, there's parts of it to think through. So there's two types. You can have an exclusive license, you can have a non-exclusive license. Exclusive obviously means this is the only other party that can perform upon those exclusive rights. Non-exclusive license means you can grant them to all kinds of different people or organizations. An exclusive license has to be in writing. It has to be signed by the owner. It provides that no one else can engage in that activity described in the license, including the copyright owner. And it can be an effective transfer of the right. So you're essentially saying this other party has the right to exercise all of those exclusive rights. A non-exclusive license can be in writing or it can be orally agreed upon. It provides that the person describing the license or the party describing the license can engage in the activity, but so can anybody else with the copyright owner's permission. So that's an important distinction to keep in mind. Next slide. So when we think about transfers of copyright, it's sort of like a level up from licensing. Any or all of the copyright owner's exclusive rights or parts of those rights can be transferred, but the transfer has to be made in writing in general and signed by the owner of the rights. It's very similar to an exclusive license in that way because you're talking about everything. The rights conveyed or the owner's authorized agent. So somebody who's working on your behalf could also do this. Transferring a right on a non-exclusive basis doesn't require a written agreement. You can bequeath a copyright by will or pass it on as personal property under applicable state laws of intestate succession or under other constructions. It can be conveyed by operation of law as well. So when you're thinking about transferring copyrights, one way to make a public record of that, which is really important so that people can understand how to best know who the owner is. You can do that with the Copyright Office through our Office of Public Records and Repositories. Just like registration with the office, which I'll talk about a little bit later, recordation of a transfer or a license is not mandatory to make the transfer valid, but it has certain legal advantages for sure. Next slide. Okay, I'm going to pivot slightly here and talk a little bit duration. So about duration, how long does copyright last for? So copyright duration has evolved over the years. For example, the first federal copyright law in 1790 in the United States registered works for 14 years with a 14-year renewal option. In the 1800s, the first term increased to 28 years. There was an option to renew copyright for an additional 14 years. Under 1909 Act, which was the first act about a little over 100 years ago, the copyright term was set at 56 years. But under the current copyright law, the Copyright Act of 1976, which is the one we're currently operating under now, the term of copyright depends on who the author is. So I'll walk you through some of that, and then we'll transition to Trevor. So copyright law today provides a current term of copyright protection that lasts for the life of an author plus 70 years. So we discussed works made for hire earlier, and the term of copyright protection for those works is 95 years from the work's first publication or 120 years from the work's creation, whichever is shorter, whichever expires first. In copyright law, an anonymous work is one on which no natural person is identified as the author. So on the work itself, no person is named or identified. And a pseudonymous work, on the other hand, is a work on which the author is identified under a fictitious name. So if you're using a pen name, that's something that would count as a pseudonymous work. I'm going to underline this by just stressing that although it's important to understand the concept and the context for the duration of copyright, the current law is life plus 70 years. And then in other cases, like work for hire, 95 years from the publication or 120 years from the work's creation. In short, it can be complicated, and it's really helpful to talk to somebody who can advise you or walk you through your own hypothetical situation. So more on that, I'll hand it back over to you, Trevor.
All right, thank you, Miriam. Well, just like Miriam was saying, copyright doesn't last forever, but it certainly lasts a long time. Let's say 100 years after the podcast that we've been talking about is published, let's say a descendant of one of the speakers on the podcast who passed away 50 years ago finds the podcast in the tribe's archives somewhere and wants to use clips of their ancestors' voice in a new documentary. Well, first, let's ask the question, is the copyright still good this far down the road? Well, okay, since copyrights generally last for life plus 70 years and the ancestor passed away only 50 years ago, maybe the copyright is still good. But copyrights in works made for hire only last for 95 years from publication or 120 years from creation. So the copyright in the podcast itself may have already expired since it's been 100 years. But, let's say we're talking just about this sound recording copyright, perhaps, or maybe the podcast was never published in the first place. Based on what we just learned about licenses, what would happen if the librarian had originally required the fluent speaker to sign a license agreement? Well, depending on the type of license, the descendant may or may not have to ask permission to use clips of their ancestor. If the fluent speaker signed a non-exclusive license, they would have retained joint ownership over the sound recording they made, only given permission to the library to use it for the podcast. But if the fluent speaker signed an exclusive license, they would be essentially giving up their right to use the recording themselves, and so the descendant would probably have to obtain permission. Similarly, if the fluent speaker had signed a work made for hire agreement with the library might very well own the recording as a compilation, and the descendant might have to get permission from the tribal library. The moral of the story is, as an ethical librarian, always have folks you record sign an informed consent agreement so they know exactly what they're doing and what you're doing. Second, always provide them with a license agreement as well, telling them exactly who owns the material going forward. It's best to include both a copyright license and a license under any sort of tribal laws that might be applicable. Last but not least, always make sure that you are following those tribal laws, norms, principles, and standards, in addition to copyright law, when doing this kind of community-facing work. All right, let me pass it back to Miriam.
Thanks, Trevor. So earlier I mentioned the fact that the U.S. Copyright Office has the role of registering copyrights as well as conducting other work. And part of that work includes providing resources to the public, and of course that would apply to you. I'll talk a little bit about what we can do in that area and walk you through what it's like to work with the office and a little bit about registration here. So our Public Information Office within the U.S. Copyright Office, these staff members can provide walkthrough service for registration. We can help walk through with a staff member assisting you in navigating electronic registration application by explaining the application screens, the types of information required. If you have a question, of course, the staff member conducting the walkthrough can point you to additional resources or additional context, but they won't be able to give you legal advice, of course. Something I'll just add in this area is that copyright registration is not required for a copyright to be to go into effect. But one of the advantages of doing so, just like one of the advantages of recordation, is it just creates a public record. This helps people all over the world understand who owns what, puts them on notice that this is something that has been created that might be part of an agreement between people and has a life of 70 years, life of the author plus 70 years. So this is helpful not only immediately after work's created, but for the duration of its legacy. Many commercially valuable works are registered for this reason. It's also how you move forward with certain types of licenses and certainly for enforcement. So there's a lot of benefits, and the full schedule of how to register, how to receive this assistance, and what any costs are all provided on our website. I just do want to stress, though, that the Copyright Office really values being accessible to everyone. And so we do have a team of people who answer the phone, who answer the emails, who are able to answer questions and, direct you to the services and the resources that we have. I'll let you flip to the next slide, please. Back one. Thanks. So the Copyright Office has a variety of different resources, and I want to point them out to you because I think that they can help you wrap your head around where you sit in the copyright system. The Copyright Office actually has a delightful exhibit called Find Yourself in Copyright, and it's one of our concepts of helping people understand, their roles as creators or as users of other people's works, and in their everyday life, in addition to in their artistic or heritage-based projects. Resources that we have include circulars like the one I just mentioned on joint works or on works for hire, which are especially important for this conversation. But we also have them on just how to register works, copyright basics, questions about international law, questions about recordation. All of that's available there. Our YouTube channel has a lot of content on it about the basics of copyright, but also about specific concepts, some of which we've talked about today. This would include short videos, just understanding what works are yours and what works might be someone else's and what's allowed. Sometimes they can be longer recordings of events that can go deeper into some of these concepts that we've held in the past. And we also have components of the website where we just narrow in on particular creative areas. So this is one that we might have for writers or for works that contain words and literary works. We have one for music. We have one for visual arts and photographers. And so as we dive into that, we're really looking at what the needs are of different audiences as we help you understand how the law works. One of the things I think is really valuable for this community to know is that keeping up with the Copyright Office and what's going on is not difficult. We do have a newsletter called the Newsnet to sign up for. So I'll just do a shameless plug for that, which is on copyright.gov/news. You'll see under subscribe is how to get directly there. You can just sign up, and then whenever we have announcements about events or other things, you'll see those come up there and they'll be delivered straight to you. You can communicate with us, of course, online, but you can do that over the phone. If you happen to be in the Washington, D.C. area, we're in downtown Washington, D.C. on the Hill, and you can come into the office and meet with people. You can also contact us through a general contact form where you can specify that you'd like a walkthrough or you have questions about recordation or registration or other services that we have. And of course, we have some social media accounts for you to keep up with us on. I'll take the last slide. So in terms of other resources that we have, we did make some notice. We noticed today through some of these examples that derivative works are an interesting concept to explore. So I'll just additionally point you to Circular 14, which of course are all on the website, which has to do with copyright and derivative works in compilations. I think this is a helpful resource to look at when you are considering complex issues in creating a work, using other people's works or your own prior works. Especially in groups of people.
Thank you, Miriam. And also thank you to Trevor and Melissa. You have heard from very experienced practitioners, and we are honored to be here with the Association of Tribal Archives, Libraries, and Museums. I also want to acknowledge and thank Laura Kaiser on Miriam's team who helped prepare today's webinar. We recorded it and sought to make it evergreen by reviewing several areas of law and applying them to the kinds of situations that arise in the work of tribal cultural institutions. We want you to be aware of the many different Copyright Office resources and tools that are available for your use. Our ultimate goal is expanding your facility with copyright so that you have greater agency and can use your own voice when making decisions applying copyright law. Thank you all for participating today. The door is always open for you at the Copyright Office, and the exhibit Miriam mentioned, Find Yourself in Copyright, is very special, as is the Library of Congress. You do not need to travel to DC. All of these resources, including the Copyright Office exhibit, are available online. This concludes today's webinar.